Good morning, everyone, and thank you for joining us for this webinar on the Building Safety Act, in which we'll focus on non-higher risk buildings. So I'm sure you all know us by now, but just in case you don't, we are Archor, a boutique law firm specialising solely in construction law matters. We set up in 2021, and there's now 18 of us, very soon to be 20, which probably, more than anything else, gives you an indication of the current construction market. So I'm Hanna McNab, I'm a partner here at Archor, and if you haven't worked it out, I'm the H in Archor. So I'm delighted, as always, to be joined by my colleagues Sarah, Lester and Hayley Morgan, who will be presenting the webinar this morning. So Sarah has recently been promoted to Legal Director, and she heads up our contract advisory team, dealing with contract reviews, preparing construction documents and advising clients on matters during the course of a project. Hayley is a senior associate, also newly promoted, and her focus is on the non-contentious side of things, acting for a range of developers across different sectors. Hayley is also our Building Safety Act queen and a fountain of knowledge for all things BSA. So moving on to the webinar itself. Now, we're not going to spend much time talking about HRBs except for explaining what they are, but we are going to focus on the general implications of the Building Safety Act. So I'm now going to hand you over to Sarah, who's going to start with a short introduction into the BSA itself.
Thank you, Hannah. Hello, everybody. Okay, so by now, I think we are, and I'm sure you are, all fairly well versed in the background to the Building Safety Act. So I am not going to, you'll probably be quite grateful to hear, spend a great deal of time talking about how we have got to where we are today, but it's probably useful to have a quick recap. As we all know, the catalyst for the changes to the building safety legislation was the tragedy at Grenfell Tower, which quite rightly led to public pressure to reform current rules around fire safety of existing and future buildings. Dame Judith Hackett was commissioned to undertake an independent review of the building regulations and of the existing fire safety laws. The report was published in 2018. It was called the Building a Safer Future Independent Review of Building Regulations and Fire Safety. Kind of did what it said on the tin, I suppose. One of the key suggestions of the report was that there was a need for a radical rethink of the whole system and how the system works. I suppose we will find out relatively soon how radical that change or those changes have been. Following the initial report, there was a relatively long consultation period. The consultation was issued in August 2019, and really to seek views from the industry on the new system of fire and building safety. Following the results of that consultation, the government issued the Building Safety Bill, that was in July 2021. It's fair to say that the bill had a relatively turbulent time through the parliamentary process. There have been a number of changes along the way. The length of liability for historic defective cladding has changed on a number of occasions. There's been quite a lot of political wrangling in relation to that position, and that's probably had an impact on some of the changes. The BSA was finally passed on the 28th of April 2022, so 4 years after the sort of whole process began. This didn't actually itself bring with it a raft of initial changes, and there has very much been a phased approach to the implementation of the Act. So where are we now? The Building Safety Act, I'm sure you know, came into force last April, so on the 1st of April 23. There was then a transitional period, so until the 1st of October last year, if a project already had planning permission, it didn't fall under the new safety regime, or doesn't fall under the new safety regime. Since the 21st of October, as I said, there's been a transitional period. If a project had planning and was sufficiently progressed, which effectively meant there are some foundations in the ground prior to April this year, it also wouldn't fall under the new safety regime. Since the 6th of April this year, any projects from then and from now on are and will be subject to the Building Safety Act. So whilst, as Hanna said, we are talking today about non-high risk buildings, that's principally because there have been a lot of seminars, a lot of presentations and webinars around higher risk buildings, which makes sense because that is what the legislation is all about. There haven't been a great deal on non-high risk buildings, and there are still some key things that you need to be considering and doing if you're involved in a non-high risk building project. To do that, we probably need to understand what a high risk building is, because a non-high risk building, of course, is everything else. Section 31 and 65 of the Building Safety Act and Regulations 2 and 7 of the Higher Risk Buildings Regulations 2023 define what a high risk building is for the purposes of the Act. The description is split into two parts. There are HRBs for the purposes of the design and construction phase of a building, which is what we're principally talking about today. And then there's a slightly different definition of what an HRB is for when that building is occupied. I think we're all really very familiar with what counts as a high-risk building. But again, just to recap, for the design and construction phase, a high-risk building is one that is at least 18 metres high or has at least 7 stories and contains at least 2 residential units, or is a care home, or is a hospital. Everything else, certainly for the design and construction phase, is a non-high risk building and won't be subject to the more stringent requirements of the Building Safety Act. This, of course, means that a purely commercial building won't ever be considered to be a high risk building for the purposes of the Act, regardless of its height. As we mentioned, the key focus of today is to consider what you need to do if you are working on a non-HRB project, and that's what we're going to talk about for the remainder of this session. So what are the requirements for a non-HRB? So before looking at what you need to do, it's probably helpful to clarify what elements of the new building safety regime that you don't need to deal with when working on a non-HRB project. The building safety regulator, which is the HSE, don't have to consult on and approve the design prior to planning being granted if it's a non-HRB. It's also not necessary for the HSE to be the building control authority. Of course, it is if you are working on an HRB building. The gateway provisions relating to approval prior to commencement and on completion only relate to HRBs. Although Hayley in a minute is going to talk about the application process in relation to building control and also the completion certificate process, because there are still significant implications that you do need to bear in mind in terms of timescales. For HRBs, there are very detailed requirements relating to the documents, the physical piece of paper that have got to be produced and how those documents are shared. They don't apply to non-HRB projects. We're going to talk in some detail about competency requirements today. There are still a number of competency requirements that you need to meet when working on a non-HRB project. They are less stringent, but they are still fairly detailed. So we'll talk about those in a moment. So what is required? We're going to spend the rest of the time talking about these 5 points on the slide here. So we're going to look at the duty holder regime, As I mentioned, we're going to talk about competency and what the competency requirements are. We're going to talk about changes to building control. We're going to talk about construction products regulations and how those are changing, and also the changes to limitation periods. Right, so the first key point is the duty holder regime. The duty holder requirements apply to any work to which the building regulations 2010 apply. So that is most construction projects. There are additional duties in relation to higher risk buildings, but the duty holder requirements do apply to everything. The legal basis, in case you're very dull like me, is up there on the slide, but it's the Building Regulations Amendment Regulations. The purposes of the duty holder regime is to really implement one of the key recommendations of the Hackett Review, and that was that there needs to be a set of duty holder roles and responsibilities so that there can be a stronger focus on building safety. These do align broadly with those set out in the CDM regulations. The key difference between the two is that the duty holder regime is based on or focuses on building safety and compliance with building regulations rather than health and safety in construction. The key point really for everybody to note in relation to the duty holder regime, or two key points really, are who the duty holders are during the construction phase of a building project, and what the competency requirements are, and really how compliance with those competency requirements can be demonstrated, because that is a really important point to bear in mind. Okay, so who are the duty holders? So duty holders who are going to be held accountable for building safety during the design and construction phase are the client, the principal designer and any other designers, and the principal contractor and other contractors. So I'm going to keep talking about the CDM regulations, and I'm sorry about that. I know today's talk isn't on CDM, but what is immediately evident is that the duty holders under the building regs can align with those key duty holders under the CDM regulations. And the obligations, the duties and responsibilities do share many similarities. As I've said, the key difference is that the Building Safety Act, or the building regs duty holders role, focuses on whether the design and construction complies with the building regs. That is the entire focus. CDM, principal designers and principal contractors, are obviously focusing on health and safety requirements. A principal contractor for the purposes of the CDM regulations can also be a principal contractor for the purposes of the building regulations. The question is a bit more complicated in relation to the principal designer role. This is because to be competent to undertake the principal designer role for the purposes of the building regs, the principal designer has to be a designer. And as I'm sure most of you will be aware, many CDM principal designers aren't in fact designers. This is quite an important point to bear in mind, particularly if you're a main contractor, because under most design and build contracts, the JCT being a key example, the contractor assumes the role of both the principal contractor and the principal designer, and that is the standard position. But unless, as a contractor, you're confident that you can be considered a designer, you won't be able to show that you can meet the competency requirements for the purposes of the building regs PD role. Our suggestion would be that if you don't have an in-house design team to enable you to demonstrate your design competency, if you're a contractor, that you should be pushing back on those obligations to take on the building regulations PD role. So now looking at the general duties that apply to all duty holders. The They are to plan, manage and monitor the work that they are undertaking to ensure that the building work complies with the building regs. To cooperate with other duty holders. Key to this is sharing information, communicating effectively, supporting each other in complying with the new building regs. Finally, there is an obligation on all duty holders to ensure that employees, design team, supply chain are all also competent. Now, this last point is really quite an important one because there is a positive obligation on each duty holder to ensure that any individual or organisation that you appoint as a duty holder are also competent to undertake the role that they've been appointed to do. So you need to be demonstrating that your supply chain, your design team have the necessary skills, knowledge, experience, and can demonstrate behaviours to carry out the design work and the building work that they're engaged to do. And also another important point is that they only undertake work that is within the limits of their competency. This means that before appointing any subcontractors or designers, or indeed the main contractor in relation to a project, you need to consider firstly, whether they're competent to do that role, and also how you're going to evidence that competency. For organisations, competence requirements include having appropriate organisational capability. Hayley's going to talk in more detail about how competence can be shown in a moment. So the client is really a very key duty holder, of course. They do have an important role to play in terms of carrying out their duties and in terms of the competency requirements. The buck really does stop with the client. They are ultimately responsible for ensuring and for certifying that the project complies with the building regs. And that is whether it's a high risk building or a non-high risk building. A key part of that sort of certification that they have to give is that they have ensured that the team engaged on the project are competent to carry out their duties under the building regulations. In practice, this means that the client needs to appoint the right people to undertake those duties on their behalf. They need to ensure that those people have the right competencies for the work, and they need to ensure that those that they appoint have systems in place to ensure that they can comply with the building regulations. These competencies, this evidence, all has to be in the form of a written evidence. So it is something that everybody needs to be considering from the very earliest stages of a project before the professional team are put together. The client is also responsible for appointing the principal contractor and the principal designer, same as with CDM, and these appointments have to be made before the construction phase begins. Moving on to the duty holder requirements for the principal contractor. So principal contractors have to comply with all of the general contractor competencies, of course, as well as the specific principal contractor competencies. I've put each of the requirements on the slide so that you have the detail to refer back to, but effectively the principal contractor duties are focused on planning, management and coordination of the building work to ensure compliance with the relevant requirements, which are of course the building regulations. As I keep saying, these align very closely with the principal contractor role and responsibilities and duties under the CDM regs. The key difference, of course, being that the focus is on compliance with the building regs rather than on-site safety. Unlike the CDM regulations, under the building regs, not later than 28 days after the principal contractor's appointment ends, so effectively that will be the end of the project, PC, the principal contractor is obliged to give the client a written document explaining the arrangements it's put in place to fulfill its duties. So effectively, the principal contractor has to give a certificate of compliance with the competency requirements, and that certificate also needs to show how the principal contractor has ensured that that any subcontractors and consultants engaged in the project are competent. So this all goes back to how we're evidencing competency. So moving on to the principal designer duties, as with the principal contractor role, the PD is responsible for all of the duties of a designer and the additional duties of a principal designer. Again, I've put all of the relevant duties on the slide, but the key focus is planning, management and coordination of designs and the building work, and that is to ensure that the works are carried out in accordance with the building regulations. Again, very similar to the CDM role, save the focus being on the building regulations. Similarly to the principal contractor role, the PD is also required to give a certificate within 28 days of the end of their appointment, which explains the arrangements it's put in place to fulfill its duties as a principal designer. We touched on this earlier and we will probably keep coming back to it, but whilst under CDM, the building regs principal designer roles are similar, the building regulations do, as I've said, expressly require that the principal designer is a designer. So some careful consideration really needs to be given to who is competent to undertake that role. I'm now going to pass over to Hayley, who's going to talk a bit about how you can demonstrate that competence.
Thank you, Sarah. So now that we have a good hold on what the duty holder regime, how it works and how it operates, it's good to examine in detail competency and how one would demonstrate competence. So a key part of the duty holder regime is that everyone doing design or building work must be competent and demonstrate their competence to carry out work in a way that complies with building regulations. The competency requirements apply to both individuals and organisations. So for individuals, the competency requirements would relate to their skills, knowledge, experience, and behaviours. Individuals must be able to demonstrate a full range of skills, knowledge, experience, and behaviours for the role that they've been appointed to. Examples of how competence can be demonstrated include completing formal training, providing a portfolio of work detailing relevant experience and knowledge, registration with trade associations, professional bodies, sector training providers, and of course awarding bodies which may be able to support the improvement, demonstration and validation of competence. For example, the CIOB now have a principal contractor competency certification scheme, which would be a good way to aid in demonstrating competence. And REBA have also released a PD competence criteria document, which provides insight on what behaviours, skills and knowledge are expected. For organisations, the competence requirements relate to the organisational capability, which is the ability of an organisation to carry out its functions under the building regulations properly. This includes having in place appropriate management systems, processes and policies to carry out its function, and having the capability to ensure that its staff have the appropriate skills, knowledge, experience and behaviours. So for example, having a robust and up-to-date training programme would help evidence this. There is an emphasis on how you as an organisation and who will be a duty holder to evidence how you're competent to fulfil your roles. You'll need to ensure that there is a system in place to allow you to evidence that these duties are fulfilled in a practical sense during the life cycle of each project. One important point to note as an organisational principal contractor or principal designer is that you will need to designate an individual principal contractor or principal designer as applicable for each project. So you'll need to ensure that you can show both the organisational competencies and individual competencies. The British Standards Institute has published a new British standard, PAS 8671 and PAS 8672, which sets out recommended competence requirements for both principal designers and principal contractors, and compliance with this is likely to be sufficient for demonstrating competence. Now we've got competency and duty holders underway, we can then go on to building control and its impact on non-HRB schemes. So with non-HRB schemes, the building control mechanism is considerably more flexible than for HRB, as there are two options in relation to who can undertake the building control role for a non-high risk building. This can be carried out by either the local authority building control or a registered building control approver, which is a new regime that has replaced the approved inspector role. If the local authority service is used, an application can be made with full plans, or in limited circumstances, a building notice can be issued. Unlike for a HRB, there isn't a list of prescribed documents that will need to be submitted with the application, but details of the proposed project, existing building, if applicable, proposed client, principal designer, and principal contractor must be submitted, along with full plans, and the local authority will then have 5 weeks to determine this application. Alternatively, if a registered building control approver is used, prior to commencement, an initial notice is issued to the local authority jointly by the applicant and the approver. Ordinarily, the applicant in these scenarios would be the intended developer. So notifying the local authority of the intended building works would be part of this initial notice, and the notice will be treated as having been accepted unless it's been validly rejected within 5 days of being given. So effectively, the local authority would be rubber stamping the approver's sign-off. Then again, with building control at completion, this kicks in again. So whether the local authority or registered building approver is being used, before a completion certificate can be issued, the client will need to certify in writing that the works comply with the competency requirements. And to do this, both the principal designer and principal contractor have to sign written declarations certifying that they have complied with their duties as a principal designer and principal contractor and are competent to do so. As discussed earlier, part of the principal contractor's role is to ensure that anyone that they appoint as a contractor or a designer is competent. So you need to consider how you're going to evidence this to enable you to sign a declaration confirming your own competency. If the local authority building control service is used, the local authority must be notified within 5 days of the works being completed, and then they'll have an 8-week statutory period to determine whether the requirements for the completion certificate have been met and issue the certificate. If you're a contractor, you'll need to consider your main contracts carefully on this point, as this is often a precondition to practical completion that the building control completion certificate is issued, and consider how this risk is going to be shared and apportioned between the parties and who will take the risk in the event that the local authority is in delay of this statutory period. If a registered building control approver is used, the approver must issue a final certificate to the local authority when the building works have been completed in compliance with the building regulations. Like with the application process, the local authority may reject this final certificate, and if so, it must give notice of the rejection within 10 working days. Again, if you're a contractor or developer alike, you'll need to consider your building contract carefully and see who is taking the risk for any delays in obtaining the final certificate, if it's in excess of these days or even within this period. Now, the Hackett report not only emphasised an issue on the duty holders, but within the products used themselves. So some construction products marketed in the UK have a legislative framework which applies to around 400 product families for which a designated standard has been adopted or a UK technical assessment applies. The BSA makes the obligation relating to construction products much wider and provides that all construction products marketed in the UK will fall under a regulatory regime, allowing them to be withdrawn from the market if they present a risk. The BSA also creates powers to make a provision for regulation of all construction products placed in the UK market, and in doing so creates concepts of a designated product, which covers the same products regulated by the General Product Safety Regulation, and a safety critical product, which the government can place on a statutory list and regulate separately. Where construction products do not fall under either of these categories, the Building Safety Act creates powers to make regulations requiring manufacturers to ensure that the products they supply are safe. There are significant civil and criminal penalties for those who breach these new construction product regulations. However, it is likely that these will apply to the manufacturers and suppliers of the products, as opposed to the designers and those responsible for the installation. Now that we've covered construction products, we'll move on to the increases in the limitation periods brought about by the Building Safety Act. So with limitation periods, we've seen a lot of debate going on, personally myself, in negotiations. and contractor to subcontractor downstream. So with limitation periods, any residential development will be subject to the potential longer limitation period under the Defective Premises Act and the Building Act, which effectively extends the limitation period for any works on dwellings to 15 years. If you're a contractor, you would need to make sure that you're passing this obligation down onto your supply chain and your professional team to ensure that you do not find yourselves in a situation where you are subject to a longer limitation period than those who have actually carried out the relevant design or installed the works. Any professionals, such as consultants, subcontractors, and contractors alike, it's advisable that you ensure you maintain insurance for this longer period to avoid being personally exposed in the event of any claims falling on you within this longer liability period. It is not only the works and design that are subject to longer limitation, as the Building Safety Act introduces a new section 10B into the Limitation Act, which extends the liability period for construction products to 15 years from the date the right of action accrues. This would be when the works are completed. So not only will the liability period apply to those designing and installing, but the very materials used also. So what do you need to be doing with your contracts, appointments, and subcontracts? So first things first, always review your building contract before you sign it. We've noted that the latest JCT 2024 suite doesn't quite go far enough in connection with building safety matters. So if there are any clauses in schedules of amendments or anything that you're unsure of, that's definitely something that we can pick up here. Also, when reviewing the contract, it's important to look for who is responsible for building control, delay and costs, as we've touched on, because the delay costs in this can be significant, and it's best to make sure that this is apportioned properly or you've made proper costs to caveat this. With PC and sectional completion, again, there can be issues here. So it's good to look at this as well as the limitation period. Does this reflect the statutory period, or is this not met? With building liability orders, again, does this reflect what's covered in the statute? And of course, if you're a contractor, who is going to be taking on the role of principal designer? If you're someone without a team of in-house designers, it's important to kind of push back on this or make sure that the client's aware that you do not feel you're competent to do this role, and that way an alternative competent professional can be engaged to do so. Again, if you're a contractor, you might want to look at updating your subcontracts or subconsultant appointments to make sure that any key points such as limitation periods are picked up downstream, and that you can then recover any damages from them in the event that they are also negligent. Again, responsibility for building control completion certificates, and whilst not strictly required for non-HRB works, we would suggest that as a contractor you obtain those declarations of competency and declarations of compliance with the building regulations downstream from your supply chain. There's also express contractual obligations to evidence competency and compliance that we would suggest are incorporated into these downstream contracts, as these will often be included within your main contract. Now we've looked at what you need to be reviewing, what do you need to be doing? So in terms of evidencing competencies, you'll need to have a written record. So this can be evidences of training programs for staff, appointing individual principal contractors and principal designers who have accreditations, such as that through CIOB, REBA and other professional bodies, making sure that the CVs detail appropriate experience that's relevant to the role that they're carrying out, and reviewing, again, your contracts and documents carefully to make sure that you are competent to do so. Looking at the risk for delays and making sure that anyone appointed down your supply chain is not only aware of what's required of them, is certifying that they're competent to do so. You could maybe, as a contractor, incorporate this into your PQQ and making sure that they're an approved subcontractor or approved supplier, and they're on the list of those registered as duty holders. Again, declarations of competency and compliance with building regulations are something that you'll need to be doing. There isn't really a set form of these at present, so the market will be reacting to these. And again, just having internal policies as an organisation, just making sure that you can evidence these competencies or have methods to evidence competencies. I'll now pass us back to Hannah, because I believe we have a few questions. But yes, thank you for your time.
Just smoothly past the laptop
Through the line.
Thank you both. So we have got some questions. We've had questions come in specifically for the webinar and just other general questions that I want to cover. First off, we've been asked this question a lot over the past couple of weeks, and Hayley, you touched on it just now. JCT has brought out a new design and build contract. Does that deal with the Building Safety Act, and what changes have been made from the previous version?
So it somewhat deals with the Building Safety Act, is probably a good starting point. So it's incorporated a new article just splitting out where you would have your CDM, principal contractor and principal designer, to now include a new article for building regulations, principal contractor and principal designer. It's incorporated a definition of the building regulations, including the requirements to comply with 2A, which is your duty holder and competence regime. And it includes a few competency requirements under the regulations for principal contractors. But in my opinion, I don't think it goes quite far enough. So
yeah, I think it's fair to say it's taken a fairly broad approach.
Quite light.
Quite light touch approach. You know, everybody's got to comply with their obligations. Obviously, there's statutory obligations, but quite how the mechanics of how each party to the contract does that isn't expressly set out in the JCT contract, which was, I think, probably what we were expecting to see. I would expect, and we certainly do see, most developers amending the JCT contract prior to 2024. Will probably continue to amend it in a very similar way to make sure that those building safety obligations are expressly set out, and everybody knows exactly what they're doing and what the penalties are and who's taking risks for what contractually.
Yeah, brilliant, thank you. And another question that we've been asked by various clients is whether a contractor can sub-consult the role of principal designer if they themselves are not carrying out the design. Sarah, you touched on this earlier, but what are your thoughts on whether they can actually sub-consult the role?
Yeah, it's an interesting question, and it is one we've been asked a lot. So the regulations themselves don't actually say, which is unhelpful. So I think it's probably going to be something that's going to become apparent over the coming weeks and months. There isn't an express right to subcontract the PD role. So I think our advice certainly at the moment is, you know, if you're a contractor and you don't have an in-house design team, it's probably best to err on the side of caution and push back on that obligation to undertake the principal designer role. Now, one interesting point that Hayley and I were discussing this morning is that the JCT contract in relation to the CDM PD role, for design and build at least, always assumed that the main contractor would undertake the principal designer role. The new contract, as Hayley said, does split out that PD role for CDM and PD role for building regulations, and it does still assume that the contractor is going to undertake that role. So those drafting the JCT do obviously assume that contractors, certainly to a degree, will be competent to undertake that role. I think as a contractor, you do really need to be thinking about that carefully, and you know, we can't say with 100% certainty that if you sublet that role you will be able to show your competence. So
especially because that applies on an individual and organizational level.
Absolutely.
As well. So it's just something to really consider quite carefully before entering into any contracts, and just make sure that you're happy to do so and feel that you are actually sufficiently competent to fulfill that role.
Yeah.
Perfect, thank you. So just some specific questions that we've had in advance of this webinar. There's a general concern about individuals being personally liable under the BSA and not being able to sit behind the corporate veil. Is this the case?
Yes, to an extent. So as with the CDM regulations, there is an element of personal liability, as breaching regulations is a criminal offence. So there will be that aspect there. So we're seeing at least a lot of hesitation from the nominated individuals for principal contractors and designers, just because the market, and as Sarah's touched on, the regulations aren't entirely clear really on certain aspects of that individual's role. So they just want to get a hand of what they're signing themselves up to, which is completely fair. In terms of the corporate veil aspect, that is largely some intention of the Building Safety Act, as there's the responsibility matrix that fell from Grenfell, and that did definitely step behind the corporate veil.
Mm-hmm. It makes sense, really, when you think about why the regulations have come into force and sort of their journey. It's really all about accountability. That was the key, really, from the reviews, from the reports, that everybody involved needs to have an element of accountability. So it does really make sense that individuals as well as organisations will be held to account where there are breaches of the Act.
Thank you. So following on from this, who actually signs the declarations?
It's another interesting question, and another we've been asked quite a lot. So as Hayley said earlier, for both the principal contractor and principal designer role, whereas traditionally with CDM, the organisation is the principal contractor or the principal designer, that's the same under the building regulations roles. However, there does have to be a named individual appointed to undertake those roles on behalf of the organisation. Again, the regulations quite unhelpfully don't tell us who has to sign the competency declarations and statements, but it would seem a little odd to have an individual appointed to undertake that role and then not have that individual sign the competency declaration. So I think certainly if you're the developer, if you're the client who has to ultimately sign off the contract and say, you know, all of my design team that have been appointed under this contract, my contractor, my principal designer, of all the relevant competencies, and this building complies with the building regulations, I think the client is going to want those individuals to have signed those pieces of paper. And also on behalf of the organisation, there needs to be an appropriate person signing on behalf of the organisation. So I think it's likely that we're going to see competency declarations being signed by both the individual principal contractor and principal designer, and also by, say, a director or a partner on behalf of the organisation.
Thank you. So we focus quite a lot on developer and contractor obligations under the BSA. What about from the perspective of a subcontractor? So what does a subby need to do to ensure compliance?
So certainly for a non-HRB project, a subcontractor wouldn't have to sign, for example, a competency declaration. That's only the principal contractor who would need to do that, and the principal designer. However, as a subcontractor, you are still a contractor. You are still appointing potentially subcontractors yourself. You are potentially subletting design elements of your work. And so you are a duty holder for the purposes of the new Act. And as a duty holder, you are obliged to show your competence. And as we said earlier, that is under the new Act, it's a very proactive thing that has to be shown. So you have to have written evidence of your competencies. So I think the first thing to say is you need to be thinking about how you evidence your competency and how you're going to keep that written record, and how you're going to ensure that anyone who you engage on a project is also competent and is also able to demonstrate that competency. The other point is that whilst you don't, for the purposes of the building regulations, necessarily have to sign a piece of paper to say that what you've done complies with building regs and that you're competent as a duty holder, if you're a main contractor and you are having to sign that piece of paper and make a declaration and sign a statement of truth to say all of those things, I think probably you're going to want your supply chain to do the same, so that you can feel confident when you have to sign it off as principal contractor. So I think subcontractors really need to sort of be prepared to be seeing these declarations included in subcontracts more and more, because I think that's going to become very commonplace. And actually, whilst there might be some nervousness around signing declarations, actually all it's doing is really saying that you've done what you're obliged to do under the regulations anyway. So provided that you are able to, you know, evidence your competency and show how you've done that, you should be fine.
And that's the point I did actually want to pick up on, is that have you had any feedback from the market about these requirements? Because it feels very much like it's things that everyone's doing anyway, but perhaps doesn't have a record of what they're doing. And it's more having a paper trail to show, well, yes, of course we get competent subcontractors. Have you had any sort of feedback from your clients as to how they're going to put this into practice?
It's
Definitely.
yes, yeah. I mean, it's obviously very new at the moment. Hayley can very much comment, I think, from the developer side.
Yes, developers are very hesitant, as you can imagine, especially with the client side obligations in connection with duty holders and the contractors alike, because it can be quite difficult negotiating with subcontractors at the best of times, let alone when you're including all of these additional documentation or onerous requirements. We will say that it's because it's new that the market always has a little bit of feather ruffling, and then it kind of softens and understands what's actually happening and what's required. And as Sarah and Hannah have already touched on, you are already doing it. It's just a case of making sure that you have that proper paper trail, which is, again, a big emphasis of the Building Safety Act, is just having that documentation trail to prove that you have done what you said you were going to do, you have designed in accordance with the regulations, and you have built in accordance with the regulations.
Yeah, definitely. And from the contractor's perspective, similarly, there is, I think, fair to say, a lot of nervousness around the declarations, particularly if you're a main contractor and you're acting as principal contractor, because you are having to sign a piece of paper to say that this will pass. But as Hayley says, under any contract you are saying that you'll comply with statute, you're saying you'll comply with the building regulations. It's really no different. I think certainly from the main contractors that I work with and who I've spoken to on this point, there is definitely this sort of emphasis on wanting to make sure that the supply chain are equally obliged to certify that everything that they're doing is compliant, which is completely understandable. I haven't actually seen any subcontracts yet that have any sort of declaration templates in, so we haven't had much feedback from sort of the subcontractor clients that we have on those in particular, but I'm sure that's something that will be coming in the next weeks. So yeah.
Excellent. The role of a duty holder, when does that kick in?
So as lightly touched on earlier, so it is pre-construction. So at the design stage and like kind of concept stage, you would expect to have your principal designer appointed to monitor the design of the work, design of what will be the project. And same with the principal contractor. Before construction actually commences, you need to have your PC appointed so that he can then manage and coordinate the works with a view of getting that construction phase plan, the health and safety file, everything across the line that you would do at a CDM perspective, but also just all of those building safety points of just managing and coordinating and just making sure that there are proper procedures in place.
Hayley, you spoke about limitation periods. Is there extended liability for non-dwellings?
Yes, there is actually. I've had quite a few, say, subcontractors and subconsultants who have pushed back on the basis that, this is, say, an industrial unit, so I wouldn't need to have a longer liability period. However, Section 38 actually applies a 15-year liability period for damage to persons or properties as a breach of the building regulations. Now, whilst this is a extended liability period, it's significantly more limited in scope compared to that under the DPA and the Building Act, because it's significantly limited to any breach that's resultant from building regulations rather than those for dwellings where it's just any defect.
Well, just linked to that point, one issue that I've been seeing a fair bit, and I think you have too, Hayley, from our conversations in the office, is pushback from consultants, I think particularly, but also from subcontractors in relation to professional indemnity cover and the length of time that the PI insurance has to be maintained under the appointment, the contract. obviously, traditionally, it's linked to the limitation period under the contract, and that's obviously because you want your PI cover in place for the same amount of time as your consultant or subcontractor is liable, for obvious reasons. It's difficult, I think, for a consultant to argue that the amount of time that you remain liable to maintain PI cover is 12 years when your potential liability is 15 years. So I think it's something to bear in mind, both if you are the consultant, subcontractor, contractor, or if you're negotiating with those parties, because really you want to make sure that the PI cover is back to back, because you don't want to be in a position where you're still liable, or you've got a party who's still liable but potentially doesn't have an obligation to maintain PI cover. And it's certainly a point to be raising with your PI insurers, because again, amendments to the length of period of time that you're going to have to be maintaining PI cover for under a contract is naturally going to extend to reflect the extensions to the limitation periods under contracts. So that is certainly something to bear in mind.
Another thing that I've seen, especially with the new negotiations as well, is consultants or subcontractors, contractors alike, pushing back on express reference in the contract to the longer liability period, saying, well, if this is statutory, why does it need to be express? It's a very good point, but unfortunately with stakeholders and so funders, purchaser tenants and that alike, the market has just meant that this is expressly required as a contractual requirement as well as statutory. And in the event that it is a statutory requirement anyway, there is no harm having it included. We would say that with the extended liability period, again, making that back to back with your insurance is just incredibly worthwhile, just because it is in your interest to make sure that you're not in a situation where you are personally exposed and don't have adequate cover in place. So again, that would be put as an express obligation for the insurance as well as the liability period.
Yeah. Just sticking with PI insurance, we've had a question come in saying, do BSA PDs require specific PI insurance covering this duty, and does this need to be clearly stated on their policy? Any thoughts on that? Have you seen any specific listings on certificates of insurance?
I haven't seen any specific listings. I mean, the PD, the obligation is that the principal designer is a designer, and I think that's the key thing. So if you're a designer and your PI policy covers you for any negligence in that design that you undertake, then I would imagine that the policy would cover you for your role as a principal designer. It's certainly something that anyone looking to undertake that role should be approaching their PI insurers and having a conversation with them about. But no, I used to review a lot of PI policies. I haven't seen anything specific yet.
So Hayley, you spoke about construction products regulator. Yes. Is the NCPR fully operational yet?
No. So for those also that don't know what the NCPR, so that's the National Construction Product Regulator. So this is again something brought about by the Building Safety Act and is in connection with the Office for Product Safety and Standards. So it was anticipated that the NCPR would be fully operational from late 2023, but details are not the most moment. We would imagine the delay is largely resultant from the NCPR just setting themselves up and testing products that are going to be used in the market or frequently used in the market, just so that they themselves have a framework in which it will assess the safety standards of those products. I understand that the OPSS, so the Office for Product Safety and Standards, are doing a webinar in connection with the NCPR, which will be question-based, and that's on Monday, but it is currently full and oversubscribed, despite me being on the waiting list. So hopefully we'll get more details on that really in the future as that progresses.
Thank you. And periods for commencement and completion of work, so the statutory periods for sign-off, how are you seeing the market reacting to those? Where are they? Who's taking the burden for those periods at the moment?
I think it's fair to say in most contracts we see at the moment, it is the contractor is certainly, as the starting point anyway, taking the full risk on delay in both obtaining approval and in obtaining completion certificates. I think for non-HRB, particularly in relation to completion, where it's likely to have a greater impact, it would be very unusual to see a building contract now that didn't say that you have to provide the completion certificate as a condition precedent to practical completion. If there is an 8-week potential period between issuing to building control and getting the completion certificate, that is certainly something that you need to be considering in your contracts, and how the risk is going to be shared between the parties. As I say, 9 times out of 10, the starting point from the developer's perspective, understandable from a developer's perspective, is that that risk falls squarely on the contractor's shoulders. I think it's something that's going to have to be dealt with commercially on a contract by contract basis.
So we've had another question come in. Main contractors have always subcontracted out PD role. No contractor I have experience with ever takes it in-house. This includes tier 1 contractors. Why are you advising not to take it on?
That's the PD role under the CDM regulations, which are drafted differently to the building regulations. The building as I said earlier, the building regs aren't clear on this point. They are silent on this point. It's also clear that the CDM regulations doesn't require the PD to be a designer, so that's another thing to bear in mind. It may be that the industry responds in a way whereby all contractors do sublet the principal designer role. It's just something that we really need to be conscious of at the moment, because unless you can sign that competency certificate as the individual PD to say, you know, I have undertaken this role as contractor, my individual principal designer is this person who I've employed, it's difficult to see how you can effectively do that if you're subletting that role. As we say, it's not clear at the moment, so definitely something to bear in mind, and we would just suggest caution at this moment in time.
Excellent. So I think that's about it for us. We're rapidly running out of time. Just leaves me to say thank you very much for joining us this morning. We hope it was useful. If you have any questions following the webinar, just drop one of us an email. Other than that, we'll say goodbye and enjoy the rest of your day. Thank you very much.
Bye. Thank you.